41, and it's a judgment of Mr. Justice Morbid. I wasn't counsel in this case, but Mr. Parsons was, and my understanding from him is that Mr. Stewart accepted certain propositions of law that were put to him. And it's said that that diminishes the authority of this case. I say that Mr. Justice Morbid did consider all the authorities, and that the statements that he makes in this case are correct. This case was overruled by the Court of Appeal. The relevant passage is a case about a transformer, and there was an issue about inherent vice. The policy, if we go to paragraph 4 of the judgment, at page 611, you'll see that they had a clause 10. This insurance shall in no case be deemed to extend, cover loss or damage or expense proximately caused by delay, inherent vice or nature of subject matter. And then one's got our institute cargo clauses A, and there's citation in clause 4, which is the same as in this case. And paragraph 7 is a discussion of the incidents of the voyage. And the judge says, the expression all risks is used in policies of insurance as a convenient way of encompassing all insurable risks to which the property in question may be exposed without attempting to identify them individually. Contract nonetheless remains one under which the insurer accepts the risk of loss occurring through the occurrence of some peril acting on the property insured. A number of consequences flow from this. First is that in order to recover under the policy, the insured must prove that the loss was caused by an accident or casualty of some kind. Insurers accept the risk, not the certainty. Second, although the insured must prove a loss by accident, it's not necessary for him to go further and establish the exact nature of the accident by which it occurred. The third is that the policy doesn't cover the insured against loss due to wear and tear of the thing insured, whether the loss was bound to occur or was fortuitous in the sense its occurrence depended on the particular circumstances to which the goods happened to be exposed in the course of the voyage. And then there's citation of British and foreign marine insurance and gaunt. And then paragraph 8 is a citation from Lord Sumner, and then one's got citation in paragraph 9 of Lord Diplock's formula in Sawyer and White. And I think one can then go forward to paragraph 19, which is headed, was the loss proximately caused by an external fortuitous event? And in our case, when we deal with Mayban, this is at paragraph 42, we have divided up what is paragraph 21 in this section with numbered sentences in paragraph 42 of our case. I'll start with paragraph 19 of the judgment. In many cases, the ability of the goods to withstand the incidents of the voyage will depend on the extent to which they're protected by packing. That's 4.3 of the Institute cargo clauses, where packing is required to enable the goods to withstand the ordinary incidents of the voyage, can properly be regarded as an aspect of inherent vice. The insurer is entitled to assume the goods as presented for shipment are packed in a way which will enable them to withstand the ordinary incidents of carriage, unless he expressly agrees otherwise, does not accept the risk of loss caused by inadequate packing. For some kinds of goods, packing may extend to bracing. It was not suggested that damage during the course of the voyage was inevitable, and indeed such evidence as there is of previous successful shipments of similar kinds of transformers makes it clear it was not. But it doesn't follow the damage was proximately caused by an external fortuitous event. Points well illustrated by note 10. And then paragraph 21 is a very important paragraph. It was common ground that the immediate cause of the damage to the transformer in the present case was the violent movement of the vessel due to the actions of the wind and sea. These in themselves were certainly events of a fortuitous nature, and they were external to the cargo, but were they the real cause of the loss? The action of the wind and waves is, of course, an inevitable incident of any voyage. And this is the part of the passage which is now divided up in paragraph 42 of our case. You can see that paragraph 42, the action of the wind and waves is, of course, an inevitable incident. Goods tendered for shipment must therefore be capable of withstanding the forces they can ordinarily be expected to encounter. In a case such as the present, therefore, competing causes, namely perils of the sea and inherent vice, are to a large extent opposite sides of the same coin. If conditions encountered by the vessel were more severe than could reasonably have been expected, it is likely the loss will have been caused by perils of the sea, even though there might be evidence the goods would have suffered the same degree of damage under normal conditions. 5. If, however, the conditions encountered by the vessel were no more severe than could reasonably have been expected, the conclusion must be that the real cause of the loss was inherent inability of the goods to withstand the ordinary incidents of the voyage. And then paragraph 22 is about mechanisms of failure. And what we've said about paragraph 21 in our case is that the first sentence is obvious. It's an inevitable incident of any voyage. Sentence 2, goods tendered for shipment must be capable of withstanding the forces they can ordinarily be expected to encounter, is in accordance with the concept of inherent vice as per Lord Dickock. Sentence 3 is correct, provided that one looks at the words to a large extent, and that caters for a two-cause case. You could have a two-cause inherent vice perils of the sea case, but often they will be opposite sides of the same coin. It means that they're mutually exclusive.
Could you give us an example?
Yes, if you got very serious weather, which was outside what was reasonably to be expected on a particular voyage, that the weather and the direction of the weather was proximately causative, applying Leyland shipping, but also one had defective packing, say, which was also causative, then you could have dual cause, with the weather being severe and the packaging both contributing to the thing being swept off the ship.
Finding a little difficult to get my head around that one. Unless you could demonstrate, which I think was Mr. Justice Morbick's one of his points, that even if the weather had been ordinary, the packing wouldn't have been good enough. If the weather is, on your way of putting it, if your weather is extraordinary, not reasonably to be expected, then I think it would follow that the packing didn't have to meet that high standard. It had to meet a lower standard for the weather that might normally be expected.
Correct.
Well, if it did meet that standard, that lower standard,
well, then it wouldn't be
there can't be two causes, can there?
Absolutely. It would only be if you had packing which was defective on shipment, applying the
defective in the sense of not being able to withstand the ordinary weather.
Ordinary incidents.
Yes.
You then say, well, it is defective. That defective quality was itself proximately causative, but it wasn't the only proximate cause. Actually, it met some really bad weather, which was extraordinary, and the extraordinary violence was itself part of the proximate cause, the extent to which the weather conditions were worse than could ordinarily have been expected. I don't see why you shouldn't have that as a dual cause case. Unusual. Most of these cases, as we see, are either the sole proximate cause is X, the sole cause is Y, or you haven't proved your case. Nita is a case where it was said it was perils of the sea, But the judge said, well, look, on the preponderance of evidence, I'm not satisfied that it was perils of the sea, therefore you lose. So it's a Poppy M. Scandia type case. And then the dicta go on to say, but of course, the fact that it wasn't extraordinary weather didn't in itself disqualify it from being a peril of the sea. That's all that's said in Nita. And that is true as a general proposition with perils of the sea. But when you're looking at the two items side by side in a policy, and you're giving effect to the policy where inherent vice is out, perils of the sea is in, they occupy a separate terrain, but in principle, there's no reason why you can't envisage particular facts in which both terrains have a contributory causative effect, in which case you resolve that with the rules that we've been through about exclusions and so on. So 3, to a large extent...
They'd actually probably cause different bits of the loss on your example, wouldn't they? I mean, supposing we take the sentence in Mr. Justice Morbick's judgment, which says, though even then there might be evidence the goods would have suffered the same degree of damage under normal conditions, and we substitute for the word same some degree of damage, then you'd say that some degree was caused by the inherent vice, the rest was caused by perils of the sea.
That is certainly possible. You might, though, have a single loss, which is the item swept off the ship and it's completely lost.
Yeah.
And you might say, well, this wouldn't have happened had the packaging been proper for ordinary incidents. Yeah. But actually, this fortuity and the particular loss was caused partly because the packaging was defective and partly because, as it happened, there was pretty bad weather here, which wasn't ordinary.
But on the example postulated by my Lord Mance, wouldn't the insured recover for that part of the damage that was caused by the perils of the sea and would fail to recover for that part of the damage that was caused by the inherent vice?
That's correct. So it's an important distinction, because Lord Mance's example is actually of two losses with different causes, whereas my example is a single loss with two contributory causes. And then 4, if the conditions encountered were more severe than could have reasonably been expected, it's likely the loss will be caused by perils of the sea. We say that one has to read that in context. The context includes second sentence, which is can ordinarily be expected to encounter in the course of the voyage. The words are addressing the position when the external fortuity of the weather and waves was significantly more severe than could reasonably be expected as an ordinary incident of the contemplated voyage. And in that situation, one had a question of causation by inherent vice, which had 3 possible outcomes. And the words, it's likely, are just indicating a view as to the probabilities as to what conclusion might be reached by the trial judge on all the evidence. And that's applying the Poppy M test. You've got to look at all the evidence in the case, all the relevant evidence to ascertain whether the loss has been caused by an insured peril. And then sentence 5 is exactly the same as the Canadian case that we've seen, No 10, and the reasoning of Lord Justice Donaldson on the causation issue. And it's saying, if you've only got one horse in the race, there's only one winner. If you've only got inherent vice as the risk, well, then that's the end of it. And if you've got ordinary incidents of the voyage and no more severe than that, you've only got one horse in the race. Now, other parts of Mayban which are important is paragraphs 30, 31 and 32, which is the application of those principles to the particular circumstances of the case, and where you draw the line between ordinary incidents of the voyage and what is extraordinary or exceptional. And he says at paragraph 30, Although this kind of statistical analysis is helpful in proving one's understanding of the general nature of events in question, I don't think it provides an easy answer to the present problem. The question whether any particular circumstances are or are not to be regarded as an ordinary incident of the voyage cannot be answered simply by reference to an analysis of this kind. The question is essentially one of fact and degree, which can only be resolved by reference to commercial experience. Conditions or events that are well known to occur from time to time, but which are nonetheless relatively uncommon, may well be properly regarded as ordinary incidents of the voyage, and then so on. But this is all the application of the principle to the facts of the case. And we adopt those paragraphs.
Has there been any commentary on Mayban?
There has. There's been Professor Bennett's article.
Yes.
And his book. And if we go to paragraph 44 of our case, we say paragraph 21 of the Mayban case, and in particular sentence 5, has been criticised by Professor Bennett both in his book and an article. And we've put out the cross-references. He contended that this understated what had to be shown to make good a defence of inherent vice, because it required exceptional weather to avoid the defence being made good. And just pausing there, one has to have in mind two different types of case. The case where inherent vice is proved by the weather, and inherent vice is proved separately, as in this case, because we know that these legs were inherently defective from evidence quite independently of the fact that they failed in this weather. And then it says, weather that could reasonably have been contemplated for the contemplated voyage could include adverse weather, which sufficed to constitute a peril of the seas. If goods have to be fit to withstand reasonably foreseeable perils, or the loss will be considered to be approximately caused by the inherent vice of the goods, or at least not by a risk within the meaning of all risks insurance, much of the point of cargo insurance disappears. All risks cover would be confined to loss of damage occasioned only by wholly unusual perils, or wholly unusual example of known perils. This criticism, we say, of sentence 5 argued from what weather could be consistent with there being a finding of perils of the sea, and to what Professor Bennett ought, in his view, to be covered by an all risks policy. Lord Justice Carnworth, he formulated the submission in this way. Globals submit, in short, that reasonable expectation or foreseeability of the adverse weather conditions from which the loss arises is not in itself to bring the case within the scope of inherent vice. And then 46, we say, Global's submission misunderstood the perils of inherent vice and perils of the sea and what's involved in deciding the issue of causation. The issue was not the severity of the weather conditions, but whether the inherent vice at Galveston or perils of the sea or both had caused the loss of the legs. What holding was to be made on causation depended on all the evidence before the court relevant to this issue. Weather conditions may be relevant, but it doesn't follow they'd be any relevant. And this is applying pure Poppy M, the Scandia case, and Lehman. You've got to look at all the relevant evidence, and you don't start categorising cases purely by virtue of the force of the weather conditions. And then 47...
Just going back to the point at the very top of that page, and what's troubled me about this whole notion of reasonable expectation is just precisely what the content is. I would have thought that any ship owner, say, ought to take all reasonable steps to protect against all reasonably foreseeable weather.
Yes.
Now, is that the same or different from the test of reasonable expectation?
I think it's the same.
It's the same.
I think that these words...
So if it's reasonably foreseeable that there might be a force 8 storm, you've got to protect against it. Or a force 12 storm, or whatever.
Yes,
so it's all about reasonable foreseeability.
All to do with reasonableness.
So it isn't really about the ordinary instance of the voyage is another word for a voyage which, during which it's reasonably foreseeable that this, that, or the other type of weather or conditions might exist.
Yes.
Is that right?
That's what we say. Yes.
And you accept that, effectively, this is the other side of the coin to what one might call cargo worthiness?
Yes.
But it has...
It's fitness for the cargo to withstand the ordinary incidents of the voyage.
Yeah.
And the insurer is simply saying, I am not liable for this. This is not a risk that I'm taking, and if a loss happens within this, I'm stipulating I'm not going to be liable for that loss. And if you want to be covered for it, you come and present, you say that you want it covered for it, and let's talk about it then. You make your disclosure, and I'll tell you whether it's an uninsurable peril or an insurable peril, and we'll rate the premium accordingly. And that's the way that business is done. And that's where the dividing line is. And then paragraph 47, the dicta and nita follow Canadian rice mill, rejecting an argument that loss by perils of the sea couldn't occur unless the weather was abnormal.
And you say that's
or
what
unexpected.
Lord Diplock meant when he's talking about behaviour in the ordinary course of the contemplated voyage.
Yes.
Yep.
It's the ordinary incidents of the voyage. And of course it depends upon the particular voyage. If you've got a little coastal voyage where you're going, you expect good weather, that's one thing. But if you've got a transatlantic, transoceanic transit of an oil rig that goes from Galveston to Malaysia, well, it's got to be fit for that voyage. And what you see on one voyage is not the same as another. But with very great respect, this was an accident waiting to happen. Everybody on the assured side knew that. They took the risk, they didn't crop the legs, and if they wanted to be covered for this risk, the only course they could adopt was to present for an insurance that covered this risk. And it wouldn't, I would respectfully submit, have been at this premium, which was 3.68%.
That is a wholly outrageous statement.
Mr. Pollock says it's a wholly outrageous statement, and he's right, because we don't know what the premium would be. All that we can say is that a reasonable underwriter presented with this risk, with knowledge of the circumstances, would never have insured this at 3.68%. Paragraph 47, the dicta and nita follow Canadian rice mills, rejecting an argument that loss by perils of the sea could not occur unless the weather was abnormal or unexpected. And we set out it can happen in any weather. And to argue that the weather conditions were consistent with finding a loss by perils of the sea, and therefore loss was caused by perils of the sea, is a complete non sequitur. And then 48 again comes back to the Poppy. And 49 we cite from Scandia, and that's again the same principle. And the last sentence of Mr. Justice Mason describes reasoning which formed the ratio for the decision in it. And that takes me on to the Hull cases. And the criticism, what is said in paragraph 61 of the respondent's case, is set out at paragraph 1 of our note on the Hull cases. To that I would ask you to go. They say that the consequences of the insurer's interpretation of inherent vice is that all the Hull's cases, starting with Dudgeon and Pembroke and Resantho at the latest, continuing for the next 150 years up to and including the Miss JJ, would have been wrongly decided. And secondly, all those cases, inherent vice would have been the sole cause of the loss, and as a result of section 55(2)(c, there would have been no cover. And we say those propositions are not supported by the case law and are incorrect. And the first case we've got is Fawcus and Sarsfield, and I've been through that. And the next case is Dudgeon and Pembroke. And Dudgeon and Pembroke is a case that was tried out before Mr. Justice Blackburn and Mr. Justice Quain. There was answers given by the jury to certain questions, and we can see that in paragraph 7, or I'll take it from paragraph 6 of the note, pleas relevant to the appeal were plea 3, denial of loss by perils insured against, plea 6, which was a plea on section 39(5), as it now is, and the policy commenced on 22nd of January 1873, which would have been the relevant date for deciding whether there was inherent vice. The vessel, after it had been repaired at Millwall, sailed from London on 3rd of February 1873. And this was a time policy, held by the House of Lords to be a time policy. The answer to the jury to the questions put by the trial judge included, was the vessel seaworthy when it started? And the jury couldn't agree. If not, was that known to the plaintiff? Answer, no. Was that unseaworthiness the cause of the loss? The jury couldn't agree. So people had a bit of a problem about which way to resolve the case. Now, the jury's findings are perfectly understandable because if we go to paragraph 8, although the repairs had been undertaken at Millwall were done under the supervision of a marine surveyor and engineer, without stint, that means without sparing any money, on the voyage to Gothenburg, she took on water. And then the carpenters at Gothenburg went to look and see why it took on water, and they couldn't find out why. And then she sailed back across the North Sea, and there was heavy weather, and what happened was that they put a sail up to try and prevent the seawater extinguishing the fires on the steamship. But the fires were extinguished, and the vessel lost power, and there was then thick weather off Hull, and she was beached. And there were therefore a series of events operating after attachment of the risk, incomplete or defective repairs at Millwall, water taken on during the voyage from London, failure to establish what caused the leak, heavy weather and heavy rolling sea on the return voyage, then entry of seawater, putting out the fires, the thickness of the weather, 14th of February, and then 6, the beaching, the vessel partly from being waterlogged and not answering her helm, and partly from the thickness of the weather. And you'll see that that's quoted from what's called the special case by Lord Penzance. And the special case appears to be the judgment of Mr. Justice Blackburn at first instance. And we've quoted from that, and it's important that it's partly from being waterlogged and partly from the thickness of the weather. Now, the issue went to the Exchequer Chamber, and the Exchequer Chamber sent it back for a retrial. And part of the reasoning for that was that you needed to find out whether this vessel was unseaworthy and whether seaworthiness had caused the loss, because otherwise you couldn't be sure that the loss had been caused by a peril insured against, namely perils at the sea. The case went to the House of Lords, who reversed the Exchequer Chamber. And they reversed the Exchequer Chamber, in my submission, on the ground that on the findings in the special case, this was at most a two-cause case, namely perils of the sea and unseaworthiness. And you didn't need to go back for a retrial on seaworthiness because that at most could only have been a contributory cause of the loss on the findings of fact in the special case. Lord Penzance stated, paragraph 9, these losses are in the contract of insurance, amongst others, declared to be all losses by perils of the sea. A long decision, course of decisions, as established causa proxima and non remota spectator, is the maxim by which these contracts of insurance are to be construed, and that any loss caused immediately by the perils of the sea is within the policy, though it would not have occurred but for the concurrent action of some other cause which is not within it. So if you have seaworthiness, which is a concurrent cause, and it's not insured, that in itself is not enough to prevent recovery, because you can have recovery for perils of the sea, provided that is a contributory cause. Mr. Justice Mason, with whom Mr. Justice Gibbs and Mr. Justice Aiken expressly agreed in Scandia, said this about Dudgeon and Pembroke. And he says equally instructive is Dudgeon and Pembroke, summarises the facts. It was held that there was a loss by perils insured against, and that a loss caused by perils of the sea was within the policy, though it might not have occurred but for the concurrent action of some other cause not within the policy. So it's a two-cause case. And then we've got our analysis. The point decided was whether on the findings in the case the assured had proved loss proximately caused by perils of the sea without the need for a retrial. The Court of Exchequer Chamber had ordered a new trial on the ground that if the unseaworthiness was the predominant cause, the assured wouldn't have proved loss by peril insured against. The facts of the particular case were considered by Lord Penzance as giving rise to the issue whether it be the case there was unseaworthiness, which could be regarded as a cause, loss by perils of the sea wasn't proved. The answer was, and then there's the quote. And then we've got the quote from Lord Justice Slade in the Miss JJ. He looked at what Dudgeon and Pembroke decided, and we respectfully adopt what Sir Christopher Slade said about the case, which is at sea. The House of Lords, while assuming that the ship was in fact unseaworthy, still decisively rejected the underwriter's plea that the loss was not covered by the policy because it was caused by ship's unseaworthiness. House of Lords felt able to reach this conclusion without the benefit of any findings of fact as to the nature and extent of the ship's unseaworthiness. It may well be that such findings, if made, would have revealed the state of the vessel was equal efficiency in causing the loss. Nevertheless, for the purpose of applying the provisions of the policy, the House of Lords was prepared to treat the loss as proximately caused by the action of wind and waves. And it was a case in which the House of Lords decided on the particular findings of fact made, given the law as to proximate cause in Victorian times. You've seen the word immediate used by Lord Penzance. Unseaworthiness could not have been the sole proximate cause of the loss. And we say that the case was determined on the basis of an immediate cause in time to loss as a test of proximate cause, which of course was a test emphatically rejected in layman shipping. And we say that Dudgeon and Pembroke, therefore, is a case which doesn't establish the proposition that a Victorian lawyer, faced with the sequence unseaworthiness, water rushing into a ship sinks, would say, well, it's perils of the sea and not unseaworthiness. The position is that Dudgeon and Pembroke and Fawkes are clear cases in which one deals with causation as a matter of fact, and one would have dealt with it as a matter of fact in Victorian times. Lord Penzance approved Fawkes in his judgment in Dudgeon and Pembroke. Fawkes was a case where unseaworthiness was the sole proximate cause. Dudgeon and Pembroke, at most, seaworthiness was a proximate cause, but it's a case that turns on its own facts. Certainly 2 judges in the Exchequer Chamber were sending it back for retrial on the basis that unseaworthiness might be the sole proximate cause. That's Lord Coleridge and Mr. Justice Grove. And that the idea that Victorian lawyers would decide that it's the water rushing in that type of time sequence which is the cause, and that that's the sole proximate cause, or indeed a proximate cause, is incorrect. That was never the law in Victorian times, and a Victorian lawyer would not have said that. Now that's Dudgeon and Pembroke. The next of the Hull cases, there's Mountain and Whittle, which is at paragraph 15. And what it was that there was a houseboat that was being towed by a very powerful tug. And the powerful tug had a very strong bow wave. And the result of that was that there was a lot of water around the houseboat, and the houseboat also had its seams were unseaworthy. They admitted water, but nobody had noticed that. And the question was, what was the proximate cause of the loss? And the answer was that the bow wave was exceptional. It was an abnormally high bow wave, and yes, it's perils of the sea. And the House of Lords decided not to disturb the concurrent findings of the trial judge and the Court of Appeal that the bow wave was the proximate cause. Particular case decided on particular facts. Frangos, it's the next one. Policy attached in March 1932. Vessel departed from Barry on 26th of November 1932, several months later. Sank on 10th of December in a heavy sea with no loss of life. No finding that the vessel was unseaworthy, and the judge says, well, I'm following Dudgeon and Pembroke, and I'm not sure whether there's unseaworthiness, but even if there was, still you've got a loss here caused by perils of the sea. What does it lay down in terms of causation? Answer, nothing. It's a case that decides on its particular facts, and it's perfectly open to the trial judge in those circumstances to reach the conclusion that there were two causes. The Gloria,
And are these two causes supposedly independent causes?
contributory causes.
I mean, this is the seaworthiness part of the cause of the perils of the sea.
Yes, because what you've got is you've got a peril of the sea, which is the water rushing in.
Yeah,
But
if the
it's
reason
not
for the rushing
solely
in is because of
caused-
the unseaworthiness of the vessel.
But it's not solely caused by the unseaworthiness. That's the point.
There being a finding, that it would, on a causation basis, it would have rushed in without the unseaworthiness.
Presumably.
Or some of it.
Presumably, some of it might have rushed in without the unseaworthiness, or there were particular conditions which were causative, like the high breast wave in the Dorrington case, the Mountain and Whittle case. I mean, with Mr. Justice Roche, he says, what is the law? This is in paragraph 19. I don't propose to deal in detail with the cases which have been cited to me, but to say, in my opinion, this case is governed by the decision in Dudgeon and Pembroke. The facts which I found, in my judgment, constitute a loss by perils of the sea. The loss is therefore one as to which the decision should be the same as the decision in that case, because even though it is doubtful in this case, as in that case, whether the vessel was in fact seaworthy or not, yet a loss caused by perils of the sea is within the policy, though it might not have occurred but for the concurrent action of some other cause which is not within the policy. The other cause which is not within the policy being unseaworthiness. So unseaworthiness, even if it existed, was not going to be the sole proximate cause. And that's a decision on the facts. Once you can reach that conclusion, all else follows. The Gloria, it's paragraph 21, there were three issues which are summarised at page 50 of the report. They were whether the vessel had been scuttled, whether the vessel was unseaworthy, and if so, whether the plaintiffs had been privy. Issue 3 was based on concluding words of section 39.5, and Mr. Justice Branson decided these issues without deciding whether loss was attributable to unseaworthiness, because he found failure to prove the plaintiffs had been privy to that unseaworthiness. No principle of law of causation is stated in the judgment. And that takes me on to the Miss JJ. And the Miss JJ case is quite a difficult case to follow. And what I would invite you to do is to take out Authorities 43, which is in Authorities 2. Tab 43 is the judgment of Mr. Justice Muster. Tab 44 is the judgment of the Court of Appeal. The judgment of Mr. Justice Muster was altered in the Court of Appeal in one relevant respect. What one had was Mr. Justice Muster held that the cause of the loss was external accidental means. The Court of Appeal held that it was a dual cause, a two-cause case. External accidental means and unseaworthiness. Now, going to our note at page 10, the policy attached on 1st of August 1979, and it covered all losses caused by external accidental means, which was taken to include perils of the sea, and it also included latent defects in the hull. And if you go to tab 43 in the head note, you'll see that there's set out the policy provided inter alia, section 1, loss and damage. Subject to exclusions and conditions, the company will indemnify the insured against damage to the insured craft which was directly caused by A, external accidental means. And then F, latent defects in the hull or machinery, excluding the cost and expense of replacing or repairing the defective part. And then there were certain exclusions. No claim shall be allowed in respect of any loss or expenditure incurred solely in remedying a fault in design, or in the event of damage resulting from faulty design, or any additional expenditure incurred by reason of betterment, and so on. And over the page. So it's important to notice that it's insured against two particular insured perils: external accidental means and latent defects in the hull. And in paragraph 23 of our note, we point out that latent defects can include latent defects which were present at the time of attachment of the risk, and therefore the policy was capable of covering loss caused by latent defects which would amount to inherent vice. And we've quoted there the relevant observations of Mr. Justice Robert Goff in the Caribbean Sea, and we've underlined a little passage just to emphasise it, where he says it's to be observed that section 55(2)(c) likewise excludes liability for inherent vice or nature of the subject matter insured. That provision is clearly inconsistent with the cover under the Inch Marie clause, and so inapplicable to a policy containing the clause. And in the footnote, we've said what the Inch Marie clause is. It's a standard clause in the hull policy which gives cover for loss or damage to subject matter insured caused by bursting of boilers, breakage of shafts, or any latent defect in the machinery or hull. And it reverses, by contract, the effect of the Inch Marie case in the House of Lords.
One bit of the subject matter insured damaging another bit.
Exactly, yes.
Yeah.
But it also covers latent defects in the hull. And what was one of the problems was the hull with these marauder vessels in the Miss JJ. If I go to paragraph 24 of our note, the vessel departed from Deauville on the 15th of July 1980, and she suffered cracking to the floor of the cruiser and loss of part of the skin of the hull in choppy, confused seas, with the hull slamming down with a bang when passing over the waves. And we've quoted in the footnote the extract from the leading judgment in the Court of Appeal where the facts are set out. And you can see there was a helmsman who was a lieutenant in the Royal Navy, and nobody criticised his helmsmanship, but he was using this very fast marauder vessel. He was slamming it over the waves. He did slow down. The conditions were markedly worse than average, but not so bad as to be exceptional. And if the conditions had been no worse than average, the Miss JJ would have been able to survive. So we've got here a case where on the facts, if you're looking at ordinary incidents of the voyage, you've got the potential of dividing them into two categories: usual incidents category 1 and usual category 2. Category 1 being mill pond conditions, easy conditions, and category 2 being adverse conditions but are still ordinary incidents of the voyage. And this would be a category 2 type case. Now, before Mr. Justice Mustill, the claimant assured put the claim both under the external accidental means and the latent defect. And Mr. Justice Mustill didn't decide the scope of the latent defect cover. A judge found that the vessel was unseaworthy on the departure from Deauville, although not debilitated in the sense that the vessel would have suffered the loss in any event, however calm the sea. And the judge held that the cause of the loss was external accidental means, viz. The sea conditions after departing from Deauville. Now, the argument before the Court of Appeal is set out in the judgment of Lord Justice Slade, and there were 2 points taken. The first was whether or not they proximately caused the relevant loss, that's the weather conditions. The relevant weather conditions were not a peril insured against by this policy. So that the argument was, well, we're in usual conditions category 2. That doesn't amount to an external accidental means because these are usual weather conditions, albeit that they are adverse. And the second point was that the loss wasn't proximately caused by these weather conditions within the meaning of section 55(1)(a). Now, we say, paragraph 27, that if the insurers had wished to raise a defence of inherent advice, they could have done, based on factual findings made by Mr. Justice Mustill, which you can find in the report. They would have wanted to avoid failing within the express latent damage to hull cover in section 1.5 of the policy. Such temptation as there might have been for the insurers to raise a defence of inherent advice under section 55(2)(c) to escape the scylla of section 1A would have been tempered by the thought of falling victim to the Charybdis of section 1F. Section 55(2)(c) is mentioned in the Court of Appeal, but the insurers didn't put the case as one of inherent vice, and Sawyer and White wasn't cited to the Court of Appeal. And on submission A, had there been accidental external means, the answer was yes, because even if weather is usual and even if it's readily foreseeable, there's still an element of fortuity in it. And there's no reason why that can't be external accidental means. And on submission B, Mr. Justice Mustill had found the vessel would have been able to survive the voyage if sea conditions had been no worse than average. Conditions were markedly worse than average, and the Court of Appeal held that there were two concurrent causes of loss, one of which was the external accident of sea conditions, and the other was unseaworthiness and departure from Dover. And since the external accident of sea conditions was an insured peril, therefore the issuer recovered. Now, where the case causes the difficulty is that there's a passage in the Mr. Justice Mustill's judgment at page 271 about causation. If we go to the left-hand side, assuming therefore, it's the second paragraph, that the cases on perils of the sea may properly be cited in the present context, what principles do they lay down? I think it helpful when approaching this difficult area of the law to draw two distinct sets of distinction. And he says, well, you can have abnormally bad weather, and then two, you can have adverse weather, which is weather that lies within the range of what can be foreseen, but the unfavourable end. In effect, the weather is worse than could be hoped, but no worse than could be envisaged as a possibility. And three, favourable weather, and it's not adverse. And then the passage which causes the difficulty, if I can read that, it's in the right-hand column. Secondly, as to causation, it may be that the doctrine of proximate cause has undergone some reassessment since the days when the most important cases on the present topic were decided. In those days, the ultimate cause was more readily identified as the proximate cause than might be the case today. Nevertheless, it is clearly established that
Ultimate means what? Last in time?
last in time. Ultimate there means last in time. It's talking about immediacy. It's clearly established that a chain of causation running initial unseaworthiness, adverse weather, loss of watertight integrity of the vessel, damage to the subject matter insured, is treated as a loss by perils of the sea, not by unseaworthiness. Now, just pausing at that colon, that time sequence is exactly the same as in the Fawcett case, where the proximate cause was unseaworthiness, and the special case was upheld by the Court of Queen's Bench and is improved by Lord Penzance in his judgment in Dudgeon and Pembroke. And then there's cited Dudgeon and Pembroke per Mr. Justice Blackburn, then per Lord Penzance at page 296, and then Frangos. And regrettably, none of those cases support that proposition. And that passage, if we go to paragraph 30 of the note, has been cited in Singapore as laying down a principle on causation. And just pausing there, if you take up the supplementary authorities volume that's attached to the whole note, and you go to the authorities 3 in that supplementary authority, and go to page 900, this is the judgment at first instance of GP Selvam, Mr. Justice GP Selvam, in Kin Yuen. And just flicking back a few pages, 897, the heading is loss by perils of the sea, then proximate cause of the loss, and we can see Leyland Shipping cited there in Canada Rice Mills. Then the exclusion principle, which we've referred to, the Wayne Tank case about exclusions. And then he says that you can have 2 causes and it's enough. The inclusion principle, that's where you get 2 contributory causes, one of which is insured, you can recover provided it's not an exclusion. And then he comes to what he calls the must-still principle. And he refers to the Miss JJ. He cites that sentence. He cites a passage from Lord Justice Lawton, which reads, the cause of a loss has to be determined on the evidence. There may be a number of causes, some making a bigger contribution to the loss than others. Under marine insurance law, the insurer is only liable for losses proximately caused by a peril insured against. What has to be decided in this case is whether on the evidence the unseaworthiness of the cruiser was such a dominant cause that a loss caused by the adverse sea could not fairly and on common sense principles be considered a proximate cause at all. In my judgment, the evidence didn't establish anything of the kind. What it did establish was that but for a combination of unseaworthiness due to design defects and adverse sea, the loss wouldn't have been sustained. One without the other wouldn't have caused the loss. In my judgment, both were proximate causes. Well, you can see that the passage in Lord Justice Lawton doesn't approve the passage in Mr. Justice Mustill's judgment. Then Frangos.
It's also a different test from the one which was adopted by Lord Justice Waller in this case, isn't it?
Yes, it is.
Dealing with the same subject matter.
Yes.
But Lord Justice Lawton says the test is one of looking at it overall and identifying a dominant cause.
Absolutely. And we say that looking at it overall on all the evidence is classic marine insurance law. Then there's citation...
And about dominant causes, he said they were both proximate causes.
Both proximate causes. I've steered clear of dominant because of Lord Clark's observation earlier.
Yeah, I see that.
Because,
on the facts of that case, they were both dominant. On the facts of another case, one of them might have been the only proximate or the only relevant one. Yes.
Absolutely. Then there's citation of Frangos. And then at letter H, 901, the conclusion to be drawn from the above authorities is this: the mere fact of unseaworthiness is not by itself a defence to a claim under a time as opposed to a voyage policy. Well, that's true. Where adverse weather is shown as an essential step in the sequence of events that lead to the loss, the policy must pay. For adverse weather or adverse sea conditions to constitute a peril of the sea, there must be something more than calm weather or sea conditions, something which men in the field commonly understand and accept as such, even though such conditions could reasonably be anticipated during the voyage. And that's all wrong. So the must-still principle, with very great respect, is wrong. It's inconsistent with House of Lords authority and other authorities. There is no principle, the must-still principle. And with great respect, GP Selvam was wrong to think there was. But returning to the note, at paragraph 31, we've just given a cross-reference at footnote 29 to 2 Singapore cases, which are later on in the whole note, and I'm coming to. Paragraph 31, Court of Appeal explained the passage in Mr. Justice Mustill's judgment as not adopting the approach of looking for the immediate cause in the sense of the most immediate in time. The approach would have been inconsistent with Leyland and Wing Tang. Passage of Mr. Justice Mustill had to be read on the basis that the experienced judge had in mind the correct issue. And then quoting from Lord Justice Lawton at page 37, in Dudgeon and Pembroke, the grounding and breaking up of the vessel was a proximate cause. I'm not persuaded that unseaworthiness followed by a loss due to a peril of the seas can never be relevant. The cause of a loss has to be determined on the evidence. And Lord Justice Slade agreed with it, and he said at page 41, this passage in Mr. Bryce's submission indicated that the learned judge regarded the condition of the vessel as irrelevant in considering the question of proximate cause and erred in so doing. The passage is economically expressed, but as Lord Justice Lawton has observed, it must be read in the light of the facts found and the issues in the case. For the reasons which he gives, I would reject these criticisms. Now, Sir Michael then wrote an article in the LCM-LQ, and the article we find at Supplementary Authorities 9. And it's an article about Fulton marine losses. And it was an expanded version of a lecture which he gave in to the Maritime Law Association of Australia and New Zealand in Hawaii on the 29th of November 1986. And at page 350 of the article, there is discussion by him of the Miss JJ. And he said that the passage at first instance in the Miss JJ was open to criticism by a severe critic, that Dudgeon was a case decided in Victorian times when the immediate cause was of significance in deciding what was the proximate cause. And you'll find that in the footnote 101 on page 350. A severe critic might wonder. His view, Sir Michael's view at 32, footnote 32, paragraph 32, was that a Victorian lawyer would consent. He says the result would have been no surprise to a Victorian lawyer, but might have caused him to raise an eyebrow was the possibility that unseaworthiness could ever have been suggested as a possible answer to the claim. After all, there was no initial warranty, and Dudgeon and Pembroke would have been seen as a clear demonstration that the sequence was not unseaworthiness. Well, that overlooks Lord Penzance's approval of Fawcus in Dudgeon. It overlooks the two judges in the Exchequer Chamber who wanted a retrial on the grounds of seaworthiness, and it overlooks the four members of the House of Lords in Dudgeon and Pembroke who worked on the basis that seaworthiness was at most a contributory cause, but they certainly recognised that it was possible as a cause. So, with very great respect to Sir Michael, we say that his views about what a Victorian lawyer would have thought would have had to take into account the views of the four judges in the Court of Queen's Bench in Fawcus, the four law lords in Dudgeon, and the two members of the Exchequer Chamber in Dudgeon as well. And then he says, in the 1980s, the position seems less clear, since the fact that adverse weather was later in time than the act of putting to sea in an unsafe condition could no longer be regarded as excluding the possibility that the earlier act was the proximate cause of the loss. In the event the claim succeeded, or not by any means without difficulty in the Court of Appeal, where it was held that since unseaworthiness was not subject of an express exemption, the fact that it was a cause of the loss, equal in potency to the bad weather, didn't prevent the court from treating the latter as a ground for recovery. And what we've done is that we've set out that passage in paragraph 32 and we've put in our comments in the footnotes. And then we've gone on to Mr. Justice G.P. Selvam's case, the Kin Yuen case, at paragraph 33. And we've said that the Singapore Court of Appeal in the same case cited a passage in Arnold, the 16th edition, 1981, edited by Sir Michael Mustill and Jonathan Gilman, paragraph 793, where the vessel encounters adverse weather or some unusual condition of the seas, which she is unable to withstand due to her unseaworthy condition on sailing, the resulting loss is still to be attributed to perils of the sea. Now, this passage included what Mr. Justice Selvam had called the Mustill principle. And you'll see that there's a slight difference between the passage in Arnold and that in the Miss JJ, because the Miss JJ was directed to adverse weather and not some unusual condition of the seas. And the passage is retained in identical words with the same footnote in the 17th edition of Arnold. And it's still not supported by the cases cited in Arnold for it. Those cases are Dudgeon and Pembroke, Frangos, Mountain and Whittle, and the Gloria. And those cases we've been through, and they don't support what's said. And the passage is inconsistent with Leyland shipping, and indeed with the decision in the Miss JJ subsequently in the Court of Appeal at pages 37 and 41. And we submit that the Singapore Court of Appeal in Kin Yuen was incorrect. The correct approach is to apply to all the relevant evidence the proximate cause case test stated in Leyland. Lord Justice Lawton, that passage that I've already read. And then Lord Justice Lawton rejected the argument of Mr. Adrian Hamilton QC, recited at page 37, left-hand column, foot of the page, that even if Mr. Justice Mustill did regard the unseaworthiness of the cruiser as irrelevant, he was, as a matter of law, entitled to do so. So the point was specifically raised and argued and rejected in the Court of Appeal. And we comment that argument was also inconsistent with the Court of Queen's Bench in Fawkes and Sarsfield. And the last of the cases in the whole note is marine offshore in China. The policy attached in 24th of December 2003, vessel departed from Singapore 26th of December. She sank in turbulent seas on the 27th. Singapore Court of Appeal held it was far from clear that the pleaded unseaworthiness, being the improper manning of the vessel, had contributed to the loss, which was ascribed to perils of the sea. Case says nothing about causation by unseaworthiness or by inherent vice. The pleaded defects in the vessel couldn't constitute inherent vice and were probably not in any event causative of the loss. And there are two paragraphs in that judgment which perhaps one ought to look at. It's in Authorities 40. If I can just turn that up. Is it Volume 2? Volume 2. It's number 40. This is in the judgment of Justice Judith Prakash. She says at paragraph 45, which is page 76 of the report, the authorities relating to the above provisions and question of proof of perils of the sea generally were examined in some detail by Mr. Justice Selvam at first instance in Kin Yuen. That was a case in which the loss was alleged to have arisen from perils of the sea, but it was common ground the vessel concerned was unseaworthy. Therefore, one of the most important points in the case was the impact that the unseaworthiness could have on the claim. Judgment drew the following principles from the authorities. Whilst ordinary action of winds and waves is excluded from the definition, just because the weather was such as might be reasonably anticipated, it cannot be concluded there was no peril of the sea. And we take no issue with A, B, C, and D, but we get on to E. The applicable rule of causation was that stated by Mr. Justice Mustill in the Miss JJ, approved on appeal by the English Court of Appeal. I.e., it is clearly, and then one's got that statement. Mr. Justice Selvam summed up the above principles as follows. The mere fact of unseaworthiness is not by itself a defence to a claim under a time as opposed to a voyage charter, and then so on. And what we've done is we've commented upon those two paragraphs at paragraph 38 of the Hull's note. Paragraph 45E, we say, is incorrect. The rule of causation is that's laid down in Leyland, followed in Wayne Tank, and Mr. Justice Mustill did not state the applicable rule of causation, and the Court of Appeal didn't approve that passage, and the extrajudicial statement by Sir Michael Mustill was not considered. And paragraph 46, what we've done is we've reproduced the paragraph, and we've got our comments starting in footnote 41. The first sentence, we say that's correct. The mere fact of unseaworthiness is not merely a defence. Even where unseaworthiness is present under a time policy, and this is not covered by the insured perils, there's no warranty of seaworthiness. In such circumstances, for unseaworthiness to constitute a defence, it either has to be a Section 39(5) case, or the unseaworthiness has to be the sole proximate cause of the loss, and unseaworthiness not to be an insured peril. Then, where adverse weather is shown as an essential step in the sequence of events, the policy must pay. If essential step means that adverse weather is a proximate cause of the loss, then it follows that unseaworthiness will not have been the sole proximate cause. These circumstances justify recovery on the basis the insured peril was a cause of the loss, and there's no relevant exclusion of loss. So it's like Badger and Pembrokeshire. And then 43, for adverse weather or sea conditions to constitute a peril of the sea, there must be something more than calm weather or sea conditions. That's not correct. Whether there's been a loss by perils of the sea depends on all the relevant evidence, and we refer to our case at paragraph 47. And for example, Scandia is a case where there was calm weather, there was just a swell, and the vessel went down, and the court held it was perils of the sea, and that was affirmed in the High Court of Australia. So that sentence cannot be accepted. Something which men in the field commonly understand and accept as such, even though such conditions could reasonably be anticipated during the voyage, and then we refer to Scandia. And that's the end of the whole note. Now, there's a point that I need to pick up from Lord Justice Waller's judgment about sole cause. And we'll need to go to Lord Justice Waller's judgment at this stage and go to paragraphs 28, 31, and I'll pick it out. Lord Justice Waller's judgment is in the Core Bible.
Paragraph again?
If we go to paragraph 28 to start with. Lord Justice Waller, in paragraph 28, he's quoting here from Arnold. The editors of the 17th edition, that's the 2008 edition, have adapted Arnold's view. They continue in paragraphs 22-25 to produce the first two paragraphs of the 16th edition, and they say, Arnold's view, which has been supported in subsequent editions, that a loss can only be said to be caused by inherent vice when it is solely due to the nature or condition of the insured property, has therefore now to be qualified. And then there's a passage there in the recent edition of Arnold. We need also on sole cause, paragraph 31. The first question is whether in Arnold's view that a cause was due to inherent vice, if something internal was the sole cause, was supported by authority. Then we go over to paragraph 56, which is the discussion part of the judgment. And we see Lord Justice Waller saying, first, I don't think Arnold's original suggested definition of inherent vice can be taken literally. Inherent vice can be cause even though some outside agency, such as the motion of the waves, has contributed causally to the loss. The calves, in the example given by Mr. Justice Wiles, is such a case. Arnold almost certainly intended his definition as understood to meaning that inherent vice would be the sole cause when any other outside causative factor didn't amount to a peril insured against. In the example of the calves, the ordinary motion of the sea would not be a peril insured against. Then 57, second, as Lord Diplock's suggestion suggests, inherent vice may not be a proximate cause if there is an eventuality or accident from without that causes the loss. Lord Diplock doesn't say whether one can have concurrent proximate causes, but taking Arnold's definition, it would appear difficult to have concurrent causes where one candidate is inherent vice. Now, Arnold was writing in 1857 about a totally different form of policy, and I have sought to explain why it is that he might have used sole cause. Namely, he was trying to define what's meant by marine perils, and he was trying to exclude from marine perils inherent vice, because that isn't a loss caused by marine perils. What one can't do is to take a policy like this policy with the 1982 clauses and simply ignore what's written in the contract, and in particular the exclusion which says loss caused by inherent vice. It doesn't say loss solely caused by inherent vice. And that is wholly unacceptable.
Was the change in 1982 in any way conscious? I mean, I'm not sure how far it follows from your argument.
I've looked into this, and the answer is I've come up with a dead end. There's nothing I can say on answer to that question which would help you.
But, I mean, on your case, it is quite a substantial change, isn't it?
It is. We know that Wayne Tank was decided in 1977.
Yes.
We know that Wayne Tank was all about Leyland shipping causation. It is inevitable that people who drafted those clauses must have known about the Wayne Tank case, which was the leading case, leading modern case on the effect of exclusions and indeed on causation.
Well, I recall it was very well known, certainly, I assume, in the marine market, you're suggesting. Anyway.
No, I'd like to help you on that.
No, but the fact of the matter is that it's not the sole limb in your argument, but it's an important limb if one concludes that there are two approximate causes.
We say that this was only ever a one-horse race.
Yes.
And if Lord Justice Waller were here, I'd say, but in the alternative, we say it's a dual cause case. And the reason why it's only a sole cause case is because actually this was an accident waiting to happen, and it was waiting to happen because of the condition of the rig, not because they happened to have waves off South Africa. And once one comes to that question and one gives it that answer, there is only one answer to this case, which is the answer given by the trial judge. And that's why it's not a dual cause case. But if it were a dual cause case, I agree, the exclusion would be very important. And it would be our burden to show its inherent vice, causation, but once we discharge it, that's the end of it. And we say that the 1982 clauses must have been drafted with Wayne Tank in mind, and that one has to construe them on that basis. Certainly one has to construe this contract on the basis of it was made in whenever it was, 2007. Clearly people had in mind Wayne Tank and everything else. It's a leading authority in this area. But anyhow, 57, Lord Diplock doesn't say whether one may have concurrent proximate causes. But taking Arnold's definition, it would appear too difficult to have concurrent causes where one candidate is inherent vice. Well, that's just wrong. Although it could be said that the Court of Appeal and Miss JJ would point in different directions, it seems to me that Mr. Justice Morbick's approach in the Maybank case is likely to be correct. And that's the one where he said they're likely to be different heads of the same coin to a great extent. And I've suggested that the words "to a great extent" cater for two causes. Of course, they must be opposite sides of the same coin in the sense that inherent vice is excluded, perils of the sea is included, and it must be separate terrain. You can't have for the same, they can't overlap in that way. Although it could be said the Court of Appeal took a different direction, Maybairn's likely to be correct. It's only if a peril insured against is not a proximate cause that inherent vice can be the sole and proximate cause. Well, that's necessarily true. If one takes the circumstance of this case, the insurance contemplated that the condition of the legs was such that they would suffer from fatigue. That was always likely to be a cause, but the fact it was a cause could not have been understood by the parties to exclude cover altogether. Well, this passage, with very great respect to Lord Justice Waller, is simply confused. If the legs snap caused by inherent vice, that is excluded. If they snap from some cause which is not inherent vice, then it is included. One doesn't get any further by simply talking about the legs snapping without going into what the cause was. Then where one has, at 59, an accident at sea such as occurred here, the burden is on the underwriter to establish inherent vice as the proximate cause. That will involve consideration of whether there was some external fortuitous event which caused the loss of the legs. And then he refers to NITA, and NITA doesn't take it any further. Then paragraph 60, Mr. Justice Mustell's classification of weather and his conclusions as to the meaning of ordinary action of the waves are important to bear in mind. Mr. Justice Mustell's emphasis on the word ordinary covers action, not the wind and waves, is intended to demonstrate the type of voyage is important, and so on. And then 62, this is the crucial paragraph. The above would seem to me to support the view that in considering whether damage to cargo has been caused by inherent vice, even if the question to be considered is, was the cause an inability to withstand the ordinary incidents of the voyage, the answer cannot be found by reference to what might be reasonably foreseeable as the ordinary incidents of that voyage, but by reference to wind or wave, which it would be the common understanding would be bound to occur as the ordinary incidents on any normal voyage of the kind being undertaken. And that's the test.
That can't be the right test to apply in a Sawyer and White type situation.
It can't be the right test to apply in any situation.
Whereas in the Sawyer and White type situation, the inherent propensity of goods to damage themselves would often only manifest itself in certain
Absolutely.
conditions of temperature and disturbance. But
Absolutely.
the question is whether it's the right test to apply where the alternative is peril of the sea.
Well, maybe. We say it doesn't make any difference whether it's peril of the sea or anything else. It must be the same definition of inherent vice. And indeed, you'll get, whether it's peril of the sea or whether it's perils of temperatures or high pressure or so on, must be the same principle. And indeed, you can get cases where it's a mixture. What do you do with those? It must be the same test that applies. This is not equating inherent vice with certainty, but it's recognising that an insurer would not cover damage to cargo flowing from the motion of a vessel in such seas, even if it wasn't certain to occur. And that's Mr. Justice Mustell and his ideas about causation floating in there. This, I hope, is consistent with the views of Mr. Justice Mustell, Mr. Justice Mustell and Mr. Justice Lloyd, and I'm not sure that Lord Justice Donaldson would have disagreed. And then he says, well, he's persuaded a more narrow test is the correct test. And the judge was, as it seems, faced with an agreement by the parties as to the correct test.
I'm not entirely sure, no doubt my fault, what Lord Justice Waller was meaning to refer to when he said the more narrow test.
I think what he's referring to there is he's saying it's not just ordinary incidents of the voyage. It's only incidents which are bound to occur. I mean, that must be a narrower test than just ordinary incidents. The test adopted by Mr. Justice Moore-Bigg was what was reasonably foreseeable as the ordinary incidents of the voyage. And Lord Justice Waller is saying it's only those incidents which are bound to occur. And of course,
Well, because all others would be a fortuity.
I don't know. I mean, all of them would be a fortuity. Most voyages...
Well, not if they were bound to occur.
Well, what does that mean? I mean, you know, you have a voyage and the temperature might be anything between, I don't know, 28 degrees and 36 degrees. What temperature is bound to occur? Same with pressure. Same with motion of the waves. Actually, there's nothing that's bound to occur in most of these voyages. They're all within fortuities and ranges. So that the test is completely inoperative because nobody knows what's bound to occur. 63, I'm persuaded that a more narrow test than that accepted by Mr. Justice Morbick in Mayban is the correct test. That judge was, it seems to me, faced with an agreement by the parties as the correct test, without the cases on hull insurance being cited to him. Well, we've cited the cases now in the hull note, and we say that actually they reinforce the conclusions of Mr. Justice Morbick, and that he was entirely correct in his judgment. What test did the judge apply? The judge summarises his findings. 110, it's not an issue that the weather experience was within the range that could reasonably have been contemplated. Nevertheless, the legs broke off some 7 days after the tow ventured out into the waters of the Cape. The judge has clearly applied the wider test as favoured by Mr. Justice Morbick. So he wasn't looking to see what weather conditions were bound to occur. I've had some concern whether anyone addressed the evidence as to the weather and waves with the test I've identified in mind. Well, nobody did. But I've ultimately concluded the case was in reality fought by the respondents on the basis that they could establish the position by reference to foreseeability and the test applied by the judge in this case. Well, it certainly was fought by us on that basis, but it was also fought by the claimants on that basis. They didn't seek any different findings of fact either. They also sought to establish certainty and failed, but didn't seek to establish a case by reference to some narrower test. It also seems to me that in finding the accident wasn't a certainty, the judge must have concluded the leg-breaking wave was not bound to occur. I've also been influenced by the finding of Mr. Justice Tucker in Nita that it was not the weather by itself that was fortuitous. He found in that case it was stoving in due to the weather, which was something beyond the wear and tear of the voyage. It's true that Mr. Justice Tucker contemplates the cargo had been properly stowed and was in good condition, but it seems to me in this case the cargo was properly stowed and was in good condition in the sense that care was taken to consult surveyors. It's not that the legs then simply suffered severe metal fatigue. Metal fatigue was not the sole cause of the loss of the legs. A leg-breaking wave not bound to occur, so we get those words again, not bound to occur, in the way it did on any normal voyage, caused the starboard leg to break off. So, however probable that wave, it might be another 99.6% probability, that's not good enough. It's got to be bound to occur. It was not certain that it would happen, although with the benefit of hindsight, we know it was highly probable. That high probability was unknown to the insured, and that was a risk against which the appellants insured. So that's the judgment. On the sole cause,
that's simply a non sequitur, isn't it? Because the surveyors passed the rig as fit, doesn't mean to say it was fit.
No,
and
it wasn't. So how does one resolve the causation issue? We've dealt with that at our case in paragraphs 37 to 41. And we say that on the relevant findings of fact, the judge actually held that the sole proximate cause was inherent vice. We say that that decision can't be disturbed because actually there was only one candidate on the facts in this case. But if we're wrong on that, Nevertheless, the finding is not to be disturbed as a finding of fact reached applying the correct law. And we say at paragraph 39, even if the weather and the waves had on the evidence been significantly worse than what was to be expected as an ordinary incident of the voyage, not this case, the unfitness of the rig for the voyage was very severe, just falling short of certain loss. And adverse weather waves for the voyage would have been no more than a concurrent cause for an accident just waiting to happen because of inherent vice. So that one goes down at most to contributory cause, and that's enough for us to win.
If the facts had been that although there was the risk of fatigue in the legs, but that it could reasonably been expected that those defects weren't such as to give rise to any risk of fatigue failure, given the reasonable foreseeability as to the instance of the voyage, and then the ship ran into something quite extraordinary and the legs were lost, the insurers would pay, wouldn't they?
Sole cause would be perils of the sea.
Yeah.
And the reason for that is that you've got two prongs to the test for causation by inherent vice. You've got to have shipment, time of attachment to the risk. You've got to identify some quality of the cargo which makes it unfit for the contemplated voyage. So there has to be unfitness. And on the example postulated, there would have been no unfitness, so that there could be no causation coming from the unfitness.
But if the ship had run into this extraordinary, unexpected weather, the legs had failed, underwriters could sell, and the claim was then perils of the sea, could underwriters then say, yes, that's perfectly true, it was a most unusual event, but the state of the cargo was such that it would or would have been likely to have happened even if the sea conditions had been as expected?
They can say that, but they have the burden of proving, in that case, that it was a contributory cause.
It would be a contributory cause. Then,
if I've understood your example correctly, you've got wholly extraordinary weather, which is itself causative of the loss. But you've got a defect in the cargo, and it's suggested that that is causative as well.
Well, the case I was submitting was the underwriters were able to establish, there was extremely severe weather, the legs came off,
Yes.
but the condition of the cargo was such that the likelihood would have been that they'd have come off anyway even if the weather hadn't been extraordinary.
Well, in that case, you might well have the proximate cause being inherent vice. Because actually the extraordinary nature of the weather didn't make any difference.
Well, that's really what I was suggesting, yes.
Absolutely. And you could well get a voyage where there are particular periods of weather that went outside what's normal or usual, which are wholly extraordinary, where it's said, well, this is perils of the sea, pay up. And the judge says, well, it's true that there was extraordinary weather, but it didn't actually make any difference. And that illustrates a wider proposition, which is that these cases are not to be decided solely by reference to the weather. The weather is only part of the relevant evidence, and the evidence makes a critical difference in all of these cases. And also, of course, one has to pay close attention to the wording in the policy. And the Miss JJ is a very good example of that, where in fact you've got an inherent vice risk that's being underwritten. So you can't just turn around and say, well, it's caused by inherent vice. So that's where we are. I need formally to deal with the new trial point, which I was going to deal with very quickly. I've made submissions in opening about that. We say that the bound to occur test is just simply wrong, so none of this arises. But in the alternative, we say this test wasn't run at the trial by the respondents, and they shouldn't be entitled to take the point now, because the effect of that is to, in effect, destroy the trial process. Means that we would have to have a new trial. Even if the test is right, they should be bound by the result of the trial which they engaged in on the basis of the test in the Mayban case. It is true that they said that Mayban was wrongly decided. It is true that they ran a causation point, but nobody sought findings from the trial judge on the basis of the bound to occur test.
Is bound to occur as a test so much more favourable for a cargo owner? Lord Justice Waller's final sentence seems to actually be suggesting in his judgment, paragraph 64, that this was really an insurance against inherent vice. The high probability was unknown to the insured, and that was a risk against which the appellants insured. But nobody's suggesting it was actually an insurance against inherent vice, and everybody accepts that there's this qualification at the very lowest, bound to occur. A cargo owner would only discover after the event whether something was bound to occur once one had done all sorts of analysis of heights of likely waves off the Cape of Good Hope and this sort of thing.
I mean, you'd need to have a very detailed inquiry, probably lasting for weeks, in which you analysed what's meant by bound to occur, because, as we've seen, it's not easy to understand where one's talking about a range of possible conditions, what's bound to occur. Perhaps you take the most favourable conditions conceivable. I mean, that's a possible test. He doesn't say that, but perhaps that's what he meant. And then you say, well, was it unfit by reference to the most favourable conceivable conditions? And then you answer that question, and then you have to deal with the causation issue by reference to that. But it's a very different inquiry from that which was undertaken at the trial, and which is undertaken, as far as one can see, in all of these cases, which is, was there some characteristic of the goods that made them unfit for the contemplated voyage? If so, was that what caused the loss? Or is it something else? Simple as that. But there's no doubt that the effect of the Court of Appeal judgment is to emasculate inherent vice as an excluded peril, and to emasculate the exclusion, and indeed to emasculate the exclusion in bills of lading and in charter parties.
Lord Justice Waller may have been saying what he did say towards the end of paragraph 64, in the sense of saying, well, a leg-breaking wave was a fortuity, because it wasn't bound to occur. To which, as I understand it, your answer would be, well, yes, all right, it was, but it didn't actually cause this loss.
No, it didn't. And we say, actually, it's just within the ordinary incidents of the voyage, and that all that is being described is part of causation by inherent vice. Because if you've got what are the ordinary incidents, they are there anyway, and they operate in the context of the inherent vice. And the inherent vice is what gives the disastrous consequence, not the ordinary incident. We quite accept that it's a fortuity. Quite accept Mr. Justice Lloyd's judgment in Sawyer and White. Well, it was a fortuity there, but it was entirely normal and usual. You can't say that that's separate from inherent vice. It's just part of the definition of the risk within the four walls. So certainly it's fortuitous, but that's not enough. So on the new trial, in our case, we deal with this at paragraph 69 onwards. We say the bound to occur test affected both the issue whether there was inherent vice at Galveston, and if so, the extent of inherent vice at Galveston, and whether the inherent vice so defined caused the loss of the legs. 70, the weather experts would have to be directed on what the bound to occur test would look like. We've put various possibilities. And then 71, bound to occur, includes only what's possible, not what's impossible. Whilst one might have had calm weather on certain days, if it was impossible to have calm weather throughout the entire voyage, then calm weather throughout was not bound to occur. So you've got to try and postulate some bad weather somewhere. And depending on what the new test required, you'd need input from experts, sea states and so on. And at the trial, nobody adduced evidence or cross-examined or advanced their case by reference to the new test. There'd been an agreement between the parties on the weather expert evidence with the agreement of the trial judge, which resulted in the parties not calling expert evidence on weather. And they must have proceeded on the mutual assumption that the factual issues of the weather and the wave should be considered were what was to be reasonably expected. Nobody was invited to address the Court of Appeal on what consequences might follow the Court of Appeal adopting the new test. Now, our primary case is that the appeal should be allowed because the insurer is not liable and that the test is simply wrong. But alternatively, we say that Global shouldn't be permitted to run a new case different from that run by them at the trial, impugning the judgment of the trial judge by reference to the bound to occur test, because it wasn't run by them at the trial and no factual findings were sought. But alternatively, we say there should be a new trial, and we point out certain relevant factors. First, the facts leading up to departure from Galveston show that Global and the contractors retained by it were well aware there were serious risks of the legs fracturing on the voyage unless they were cropped. Secondly, Global were advised in strong terms by their consultant prior to the voyage to crop the legs. Global could have sought insurance which covered the risk of loss caused by inherent vice, as did the assured in Sawyer and White. Then there would have had to be disclosure, and the insurers would have had an opportunity to consider whether to insure it or not. And if so, what premium? And Global obtained all risk cover with inherent vice as an excluded peril, an express exclusion of loss caused by inherent vice, and the insurer, in agreeing to the policy, including the condition for a marine surveyor to be nominated and improved, wasn't taking on any of the inherent vice risk. And this was clear to Global and their brokers from clauses 1 and 4 of the policy. The insurer did not insure against fracture caused by inherent vice, and we contrast that with paragraph 64 of Lord Justice Waller's judgment. And before Mr. Justice Blair, Global relied on the premium of $378,000 as supporting their case. They were covered for loss of the legs, and that the premium agreed for the policy was 3.78%, and it was with its express exclusions. And given the findings of Mr. Justice Blair and the probabilities of the loss occurring, 3.78% bears no relation to the risk of loss by inherent vice in this case. The agreement between Global and the insurer on the weather, acted on by the judge, was the mutual basis that the meaning of inherent vice was stated by the House of Lords. Neither side at the trial anticipated application of the bound to occur test for inherent vice.
Yes, but
it's not fair to single us out.
That's to some degree correct, but of course what wasn't agreed was what the meaning of inherent vice was, as explained by these cases.
That is true.
That was the
absolutely
argument.
true. And I accept entirely that they argued causation by inherent vice, and they argued causation by the wave, and certainly they said that Mayban was wrongly decided. But it was all in the context of it's the wave.
All in the context
of the wave being the proximate cause. And the bound to occur test is another test. It's another variant on the case that was argued. So one's got gradations there. And certainly it is difficult to talk about a causation issue unless you say what it is that is causing the loss. Got to have some definition of inherent vice.
Well, we know what caused the loss, don't we, in this fatigue kind of situation.
Yeah.
It's the state of the vessel,
Yeah.
and where it is on the spectrum of its fatigue life, and the amount of stress or stress cycles it goes through until the moment juste. Those are the two aspects of a failure by fatigue.
Absolutely.
in your cases, the wave is just the straw that breaks the camel's back.
Or to use Lord
Or
Shaw,
another way, the proximate cause.
yes, we say that the wave was given its disastrous consequences by the fatigue. The wave would have
It's
been
very difficult
anything.
to say that the wave isn't a cause, at least. Possibly even
It's
a
not a
proximate
proximate
cause.
cause, but
Yes.
it's given its devastating power by virtue of the inherent vice and the fatigue. Otherwise, it would have been of no consequence whatsoever.
So one possible view is that they're both causes, but from your point of view, as long as the fatigue is one of them, then
Well,
you have clause
we say it's
4.
not. We say it's not proximately causative. It's not caused within the meaning of the policy. It's not Leyland Shipping caused. It's simply the trigger. It's simply the thing which is given its disastrous power by the state of the vessel, or in this
usually
case,
pulling the
state of
trigger,
the-
however, causes the trouble.
It's the trigger.
There we are.
We call it the trigger. It's probably the best word to use for it. So
The
certainly-
trigger is slightly difficult, isn't it? Because the trigger for the ship going into Le Havre after being torpedoed and eventually grounding and breaking up, the trigger for all that happening was it being torpedoed, you could say.
That's right. Well, yes, but it was a bit more than a trigger, wasn't it? It was the proximate.
Yeah, that,
cause.
all I was saying was trigger
Yes.
is not perhaps
No,
the word that answers the question.
no, it doesn't. I'm using it simply as a word where it's true that it's a causative test, a causative step, but it isn't proximate cause. It's something which is part of the mesh, as Lord Shaw would say, of cause, but it isn't the proximate cause or even a proximate cause.
Because it's something that's likely to happen in the ordinary course,
In the ordinary
bearing
course.
in mind the condition.
Absolutely. I mean, there was this vessel with the people on it, and it had been torpedoed. It was very, very badly damaged. It might make it, it might not. She couldn't go into Le Havre with the Red Cross. She gets beached, gets grounded from time to time, and she breaks her back. Answer, it's the torpedo. And if one went to the man in the street, he'd say, well, it was the torpedo. And similarly here, if you ask what caused this, the legs to fall off,
He'd say
the man in the street
He'd say the fatigue and the stress is what he'd say.
he'd say it's the fatigue and the stress. He wouldn't say, well, it's the fact that they've got an ocean off South Africa and that ocean has waves in it. Of course it has waves in it. That was part of the adventure. That was just an ordinary incident of the voyage. You wouldn't say it's because they've got an ocean off South Africa. You'd say, well, it's because it's unfortunately it wasn't in a state where it could cope with the incidents of the voyage. That's what caused this. So that's all I was going to say.
But that's it then, Mr. G, so far.
That is it so far. We formally put in our case. We formally put in our Hull's note, of course. I've gone very, very quickly today. I haven't read all the authorities. And I'm here to help. That's all I say.
Thank you very much. Mr. Stevenson, is there anything you wish to add?
I have nothing to add. Thanks.
Yes, Mr. G. Mr. Pollock.
My Lord, I think it's important that one should have clearly in mind how the loss comes about, because it's very important to remember that the problem is fatigue caused by the voyage only. My learned friend says from time to time these were defective legs. There were problems with it. There were no leg problems in Galveston whatsoever. The legs were fine in Galveston. The legs were lost because of fatigue induced during the course of the voyage. And the issue at the end of the day, and it's a very simple issue, is whether or not a susceptibility to damage being incurred or being induced or inflicted upon the subject of the insurance during the course of the insured adventure amounts to inherent vice. Because if the answer is yes, that is going to carve an enormous swathe through what hitherto has been thought to be the cover that one's getting when one takes out either a hull policy or indeed a cargo policy. Now,
Where's the evidence? Both of you say that any result which is against you will make a radical inroad into present
I'll
ideas.
explain why. It's not a question of evidence, it's more a question of argument and reasoning, if I may put it that way. Now, this is not a case of internal deterioration such as occurs when you have something that is subject to microbiological action, or whether you have internal spontaneous heating, whether you have sweating, putrefaction, rotting, or the like. All of the classic cases of inherent vice that one finds, and there are not very many of them, but one does find some, scattered through the law reports or referred to in the treatises, relate to things of that nature. Sweating, internal moisture coming out and going back in, spontaneous combustion, and so on. Now, the mechanism of the loss in those cases is internal. The damage occurs, remember what Lord Diplock says, a loss by inherent vice, the inherent vice describes the mechanism by which the loss occurs. And so you start off with the loss and you ask yourself, how did it come about? And in all of the classic cases, it comes about because of the operation of an internal mechanism within the goods, the cargo, or whatever. In this case, the mechanism for the loss is entirely external. Nothing happens within the rig legs except on the basis that some external force hits it and affects the metal. Now, whenever a metal artifact puts to sea, it will, unless the conditions are those of a mill pond, be subjected to stress. That just happens. And if you're floating absolutely calmly, nothing. But the moment you start to move, some degree of stress is being inflicted on the metal because it flexes, because it moves. And the stress can be enormous or it can be very light depending on the sea conditions. And if you have sufficient time and sufficient stress, the metal of any artifact floating on the sea will be damaged and will eventually fail. And we've all, in our time, or not all of us, but many of us, have done cases of brittle fracture and plastic fracture, and in went the sea, and lo and behold, the cargo got damaged. Now, the stress is caused, as I say, by the fact that the wind and waves cause a vessel floating on the water to roll and pitch, plus the impact of water, because of course water weighs. You get a big enough wave hitting you, you're in fact subjecting metal which flexes under the impact to tons and tons of weight. Now, the operation of wind and waves on a vessel, whether by imparting motion or by impact, are paradigmatic of the concept of perils of the sea. And that's what we taught. It's the classic example of a peril of the sea. There are others. Collision, stranding, hitting rocks, being in fact blown over onto your beam ends and so on. But the classic example of perils of the sea is the effect of wind and waves on a vessel and indirectly on cargo. And damage caused by the effect of rolling, pitching, or impact is the most obvious case of damage caused by perils of the sea. It's only on the sea that kind of peril force operates. If you're on land, it's something different. It may be wind, but it's not the waves and so on. Now, the mechanism of damage in this case, that you then think about it in that context, is these legs, as your lordships can see from the description in the judgment, are absolutely massive steel structures. They are 300 feet high, or 300 feet long, either going down or up, depending on whether they've been...
There is actually a picture.
Oh, your lordship got a picture? I haven't noticed
in the
that
appendix to the Statement of Relevant Facts and Issues, page 612, is what I have assumed to be a picture of the rig on the barge.
Okay. Your lordship has this right with me. I've never managed to penetrate.
Appendix to the Statement of Relevant Facts and Issues.
There are quite a few
It's a
volumes. What page is it?
thin volume, 612.
There are quite a lot of there are a lot of volumes entitled Appendix to these.
Oh, yes, here, I was thinking.
Oh, yes, I have seen this. Somewhere else, yes, quite right. Yeah. That is it. Well, your lordship sees, the normal course, the legs go down to the bottom, you jack them up, and it stands on the barge, and the barge sails. The legs are absolutely enormous, and they are very, very thick steel. And as your lordship sees, the problems are what are called the pinholes, which is the pins on the basis of the pins are very massive pieces of steel that go in to hold it. But you've got the pinholes, and as we remember from many a piece of expert evidence, it's where you get the corners that you get the stress concentrating and the fractures beginning. So when the barge sets out in anything but a mill pond, the movement of the barge, which is induced by the presence of waves and swell, is going to stress those metal legs, and that is inevitable. The degree of stress is entirely a function of the height and orientation of the waves, because it's all calculated on the basis of the motions that the legs are going to travel through on the top of the barge, and that depends which way the waves are coming and how big and heavy they are, therefore how much you sway. But you have to remember that the increase or decrease in the level of the stress is not a simple arithmetic ratio. And this is because, as the judge sets out in his judgment, it's calculated as a cube of wave height. Now, the point about this is that a comparatively small increase in wave height can increase the stress substantially, and equally a comparatively small drop in wave height can decrease the stress substantially. So departures from expected or predicted sea states by comparatively small amounts can have a comparatively dramatic effect on the degree of stress that the legs were going to be placed under. And this is one of the reasons why, as the judge points out, prediction as to when fatigue life is going to be used up and what is going to happen is an inherently uncertain affair. You don't just say, I can sit down, run it through my computer, this is going to fail, this is not going to fail. You're having to do a lot of very complicated calculations on the basis of all sorts of assumptions, and as was demonstrated through the trial, time and again, as the experts changed their assumptions, either for their own purposes or under cross-examination, the results then varied wildly over a comparatively substantial gap. Now, I don't say this to indicate that the judge was not right in coming to the conclusion that he did about probabilities, but I'm just saying that this is not an exact science, and that is relevant when you look at what people do and what people are ensuring. So stage one is that the rig sets out to be towed with the legs in the air, and the application of some degree of stress is a certainty, because you're not going to get a mill pond on the way from Galveston to Malaysia. Stage two in the process of failure is that the metal has a finite stress life. And that means that once sufficient stress cycles have been inflicted on the metal by reason of the motion induced by wind and waves, the composition of the metal at points of stress concentration can alter. Indeed, it's predicted that it will alter as soon as you've had a certain number. And when I say a certain number, those are not predictable. It's not 107, it's not 2000 and this. It's when enough have happened is all that you can say. You can tell it's happened after the event, but you're not going to be able to predict precisely in advance when that will occur. And a consequence of the alteration of effectively the molecular structure is the initiation of a crack. That is a change in the integrity of the metal. The outset, this is microscopic, and then it is going to grow. Now, once again, it's not an exact science when to predict if that is going to happen, when it is going to happen. You're going to be able to say the probabilities are this, that, or the other. Stage three is the process of the propagation of the initial microscopic failure into a crack which ultimately becomes visible. The propagation of that crack requires the continuing imposition of stresses caused by wind and waves at the sea, and the degree to which any particular crack will propagate, the speed with which it will do so, and the extent to which it will do so, is again a function of the size of the stresses which are being imposed, which is a function of the size of the waves, the orientation of the waves, and so on. Stage four is the propagation of a crack or cracks to the extent that if the right pressure is imposed in the right way, the leg will actually break off. In other words, you have a potential leg-breaking crack. And that has to be quite a substantial size, inches long. 6 to 10 inches, 5 to 7 inches, something quite substantial. Stage 5 in the failure process then is the arrival of the leg breaking wave. And this has to be a wave of sufficient height and power and orientation which hits the barge just right and it snaps it off. And that's, you've got the quotations in the judgment of Mr. Justice Blair, the expert that says you have to hit it just right. In other words, it's not every wave, it's not certain. It may be probable or highly probable that such a wave will arrive over a period of time, but there's nothing certain about it. And that then causes the crack to shear all the way around. And as the experts say, and it's quoted by Mr. Justice Blair, this is still, even with a 6-inch crack propagating from a corner of one of the pinholes, going to require a pretty substantial blow to break off this very, very heavy, thick steel leg. Now, the insurers, as your lordship know, invited the judge to find that the loss of the legs was inevitable. In other words, that it was inevitable that each and every one of those stages would be completed.
Just when you get to your stage 5, the leg breaking wave.
Yeah.
I mean, this is a wave that doesn't actually hit the leg, or am I wrong about that? But is of a particular quality.
It doesn't hit the leg.
No.
It hits the barge in such a way as, in effect, to make the barge move, so that the stress that is then imposed on that oscillation is such that it gives way.
And presumably the amount of force you really need to do that depends upon the precise state of the vessel, of the metal at that moment. If it's sufficiently far gone, you'll need a less of a force than if it isn't.
Well, I'm not sure, I wouldn't like to say whether that's true, because I think what the experts had in mind, that once you get to a certain length of crack, then a wave of the right sort will do it. And the cracks may go on propagating and get even longer.
It presumably depends upon what size of crack you're postulating.
I think there's a minimum size of crack that they regard as necessary before it is likely that the right wave comes along. Your lordship may well be right that if that right wave doesn't come along for several days and you get cracks that go on growing, then perhaps a slightly lesser wave.
Yeah.
But you're talking about waves that are meters high to do this. You're not just talking about a gentle swell, you're talking about quite strong. But the kind of waves, as the expert said, that you not unnatural to encounter as you pass round the Cape. It's an interesting prospect in this case, whether if it got round the Cape successfully and made it into the Madagascar Channel, it would then have been in waters which might have allowed it to get...
It wasn't past Cape Town.
Yes.
It was, I thought it was, yes.
It stopped at Cape Town,
Yes.
left Cape Town, it was a couple of days past, you're going up the east
Up
coast.
towards Durban. Or...
What they had done, yes, is they had changed their plan so as to go up the Madagascar Channel on the basis that the water would be calmer, rather than heading straight across to pass the southern tip of India to go up to Malaysia. So I think it was going to go up and down and round.
Well, once you get a wave, you get the leg in a condition where it's liable to go if the rig is hit by the right leg breaking wave. Presumably, it simply falls off. It doesn't. It's a brittle fracture which runs round, and
it snaps
the whole leg
and
just
falls
falls into the sea.
The risk is, will it go into the sea or will it fall onto the rig and smash up bits of the rig? Happily, in this case, all 3 legs fell into the sea. And the point is that once the first leg is gone, this increases the stresses on the other 2 substantially, because you would now have an asymmetric configuration. And so effectively, if you lose the first leg, the rest are pretty well bound to go.
Well, that presumably unbalances the rig, and the whole thing is moving
the
much more.
way it oscillates, the way the remaining legs move around in the air as the barge pitches or rolls. So the judge declined to find that the loss was inevitable, and therefore, apart from the fact that we concede stage 1, that if you're not in a mill pond, there's going to be some degree of stress, he has made no actual fact findings that the occurrence of any of these stages was inevitable. All he was prepared to do was to find that unknown to the parties, and I stress unknown to the parties in the light of the way my learned friend has allowed himself to put this, that it was probable, even highly probable, that a crack of sufficient size would have occurred in one of the legs prior to the end of the passage, and that it was probable, even highly probable, that a leg-breaking wave would be encountered after that crack had formed, with the consequence that the relevant leg would come off. Now, if I could just then say this before I pause, the mechanism of the loss was breakage by a wave of sufficient height and power which hit the barge just right, and the risk of a leg-breaking wave taking the leg off came about because during the course of the voyage, the structure of the leg, the metal, had been damaged by the application of an entirely external force, namely waves of sufficient height, power, and orientation allied to wind. So there was nothing in the cargo, the rig, which was eating the metal away or weakening the metal. Nothing in the cargo which contributed in any way to the chain of causation without the application of external physical force. There was nothing wrong.
Except the initial state of the vessel.
Sorry?
The initial state of the metal.
Well, the initial state of the metal was perfectly satisfactory.
Well, as long as no...
As long as you didn't take,
stresses,
as long as you didn't subject it to stresses which were going to destroy it. Because that is true of any piece of metal.
I follow that every bit of metal has
is
a
subject
fatigue
to
life,
this.
and sooner or later it'll fail by fatigue.
Now, what I'm saying is that what your lordship is saying is the strength, the inherent strength of the metal, as it turned out, was probably not sufficient to enable it to be subjected to the stresses which the projected voyage would probably subject it to. That doesn't mean that the metal was defective or weak or anything. It just means if you take a piece of metal and subject it to stresses which it's not in fact meant to bear or manufactured to bear, you will have problems. But it wasn't debilitated or particularly weak in any way, and it was not the subject of any prior damage which was going to make it particularly weak for these purposes.
Aren't you there actually only dealing with the first two words of the relevant exception? Because both in the Act and in clause, the cargo clause, I think we're talking about loss caused by inherent vice or nature of the subject matter covered. So I think the argument against you on that point would be this is just part of the nature of the it's nothing wrong with it, but the fact is that it's not suitable for this length of voyage through these seas.
This turned out not to be suitable for this length of voyage.
Yes.
That is correct. Whether that is the nature, I mean, I'm not quite sure that I would agree with my learned friend where he says the vice and nature of the thing are different. Simply vice was a rather Victorian word that was used, and people got into the worry that it meant something vicious and therefore dangerous. And people said the vice of an animal, and the answer was not that the animal wasn't vicious at all. It was simply an animal with the normal characteristics of an animal. And that's what inherent vice means.
Well, Mr. Pollock, I think we'll leave it till tomorrow at 10:30, please.